This is the first of a new feature of our meetings, of hot topics session, which, as its name indicates, we'll talk about various kind of current events. The one this year having been chosen being constitutions and revolutions. I should mention that this panel is really organized by Ralph Michaels, who is the program chairman, and who really introduced the idea. I am sorry to have to tell you that Quasi Prempe, who was supposed to be on the panel, unfortunately had to cancel and will not be here, leaving us with two panelists, although two excellent and interesting speakers. The topic, as I mentioned, is revolution and constitution, and I hope I can start by taking a few minutes to talk about say a couple of things about that subject before turning the session over to our two panelists. I don't know, and you'll have to ask Ralph, who wrote the description and chose the topic, but one suspects that part of the appeal of this topic, the combination of these two ideas, is that they, pairing them suggests a certain dissonance. Constitutions, we think, are the guarantors of law and the rule of law, whereas a revolution represents a disruption and unsettling of a legal order. The first point which I would make about this topic is that notwithstanding this apparent disharmony, in fact, revolution and constitution are, at least in one sense, logically inseparable. A constitution represents the highest level of law in a legal system. Constitution is the authority for all other law, but is itself something not authorized by any other law. That being the case, where does a constitution come from? How does it get to be a constitution? If the definition I've given is right, it follows that it must be the product of some illegal, that is, entirely political event and decision. But in the facts are that the institution of a new constitution never takes place in a lawless society, never takes place in a state of nature, in fact. A new constitution inevitably replaces some other ultimate legal rule. That process, the process of replacing one Grundnorm, if you will, with another, I think is often what we mean when we say that a revolution has taken place. If that's right, then it follows every constitution originates in revolution. And every application of a constitution, which is to say really every application of law, is the implementation of a revolution. That is no revolution, no law. That's one point. Second point, also related to this apparent opposition of constitution and revolution, is that we observe that revolutions often involve a certain puzzle. That is, though they are revolutions, the actors, the participants, tend to stud them with expressions of what look like positive law. That's a puzzle, I say, because on the reasoning that I've just mentioned, the moment of revolution being the abandonment of one system of law and the institution of another, being the moment between legal systems, must logically be an event outside of any law. So what kind of law could it be that the revolutionaries are talking about when they cite rules of law? I'll give you one of my favorite quotations. In the 1821 Constitutional Convention in New York, there was some argument, some debate about the extent of the convention's powers, what it could do, what it couldn't do. And one of the delegates responded that the convention was, on the reasoning I just mentioned, logically immune to any such restrictions. He said, "Sir, we are standing upon the foundations of society. The elements of government are scattered around. Yet, these revolutionaries seem to assume that there is some law which they can appeal to, which will justify their actions, and which constrains them. Often very concrete, positive laws. Give you an example, a relatively recent example from a revolution. This was the 2005 revolution in Kyrgyzstan. This was known as, you might remember, the Tulip Revolution. I'm not an expert on Kyrgyzstan or on the Kyrgyzstan Revolution, but I know this, there were, as we've all seen in recent months, there were mass demonstrations, there was largely a breakdown of public order, political prisoners were released, the president fled the country, and these former political prisoners, some of them took over the positions of power. But once they were in power, they took great pains to conform their acts to the existing positive law rules of the regime that they had just overthrown. And there were days and days of debates and fretting and fussing about how to get the ousted president to sign a letter of resignation, which they ultimately got him to do. I could cite other examples. What's going on here? I will give you one suggestion, although there may well be other explanations. Many of the revolutions that we are most familiar with have as one of their substantive objectives the institution of a state devoted to the rule of law. That is, they are rebelling against a government that they see as arbitrary and acting unlawfully. So the revolutionaries have to champion the values of legality while they themselves are necessarily acting without law, at least without the law of the old regime. So it may not be surprising that, at least in terms of legal rhetoric, we often find revolutionaries displaying a kind of a cognitive dissonance. Well, these are just observations, questions, relatively random. Our panelists, I'm sure, will touch upon related things and many other things in the context of the contemporary wave of revolution and constitution making that we are observing. And I will only mention our two distinguished and accomplished speakers. The first we will hear from Richard Albert, who is a professor of law at the Boston College Law School. He will be followed by Professor Donald Horowitz, who is the James P. Duke Professor of Law at Duke. Each of our panelists has been allocated about 20 minutes. They will be kind of liberal 20 minutes as well. My main job now is to try and persuade them to stay within those limits. Luckily, the organizers of the last panel have left me with the tools of my trade, so I will, at the relevant time, display them, each being somewhat more conspicuous for the second than the first, and then we rely on what we used to call shame sanctions. After the panelists have spoken, we will then have some discussion, perhaps among the panelists, and then I think, still have a good amount of time for discussion and questions. So my great pleasure to introduce first Richard Ellis.
Good morning. I want to thank everyone for your hospitality. I'm really thrilled to be here. Ralph Malkels, thank you for inviting me to participate in the program. Frank, thanks for your hospitality. Let me just say a quick word about why I think I was invited to participate. I think it's because Richard and Rick, share the same name. But I'd like to think it's because I've thought about the subject of revolution for a bit with some depth, and hopefully I can bring to bear some of that this morning. Just as an aside, Rick knows this, but you guys don't know this. Rick is actually one of the reasons that I got interested in comparative constitutional law. As a first-year law student at Yale Law School, I began reading the work of comparativists, one of whom is Bruce Ackerman, the other is Kim Shepley, and Rick. And so that's my triad, and so it's really an honor for me to be sitting alongside Rick today on this panel, and honored to be here with you guys as well. The subject of my very short remarks, about 15 minutes worth this morning, is democratic revolutions. Democratic revolutions. Revolution is the story of the day, and I think rightfully so. With the potentially seismic changes underway in Egypt, Tunisia, Libya, I think it's right for us to be thinking about revolution. But most of the discussion enveloping the subject of revolution, I think, has obscured some of the larger theoretical questions about revolution. Namely, what is a revolution? And how can we tell whether and when a revolution has occurred? These are important questions, and I think these are questions that conventional theories of revolution can't help us answer. We can't answer them satisfactorily using conventional theories of revolution, because these theories speak of revolution in one voice on these questions, and I think that voice is mistaken. And my goal for the morning is to try to convince you why these conventional theories of revolution are mistaken. And so I'll leave it to you to let me know how well I've done. Conventional theories of revolution are procedural, they're amoral, and they're mechanical. They frustrate the possibility of cultivating a concept of a democratic revolution precisely because revolution theory invites no judgment about the merits of revolution. The amorality of revolution theory as it currently exists in turn leads to the lamentable consequence of being unable to distinguish between virtuous revolutions and vicious ones, between democratic ones and undemocratic ones. And so my time today, I'd like to suggest to you that revolution theory can do better, and I think I have a plan for suggesting how that might be done. My object, though, is not to redefine revolution. It's rather to give content to the concept of a democratic revolution, so that we can be able to distinguish along structural terms, this is very important, structural terms, democratic revolutions from undemocratic ones. So how might we begin to shape the contours of a concept of a democratic revolution? I think we have to begin by recognizing that revolution theorists have stripped revolution of its normative content. They understand and define revolution in purely structural and procedural terms that deny revolution the force of reason that once gave it such a very powerful democratic significance. And I think the consequence of this proceduralist approach is troubling. Events and episodes that suppress democracy, that deny freedom to citizens and restrict popular choice, receive the same once vaunted designation of revolution, as do more noble events and episodes that celebrate democracy, that expand the range of freedom of citizens and multiply popular choice. I think that's part of the story about the disconcerting amorality that underpins process-based approaches that help us characterize what our revolution really is. So that's the first step I think we need to take if we want to cultivate a concept of a democratic revolution. The second step is to deconstruct conventional theories of revolution and perceive that revolution scholars have reduced revolution to one of three deceptively appealing propositions, each of which I think undermines the broader moral force of revolution. So three propositions. The first is that conventional theories of revolution connect revolution to violence. dwelling on the violent dimensions of revolution and on the shock that revolutions descend upon civil and political society as a result of the use or misuse of military might or armed aggression. That's the first point. The second proposition is that revolution theory understands revolution in terms of mass mobilization, romanticizing revolution as triggered and prosecuted by social movement politics and as infused by the legitimacy that only popular participation can confer. Third, revolution theory entails a temporal dimension, pursuant to which revolution necessarily involves speed. So on this point, revolution scholars set revolution in opposition to evolution, impressed as they are by the immediacy of revolutionary change and the rapidity with which it is achieved. And so conventional theories of revolution therefore define revolution according to these three themes: violence, mass mobilization, and speed. Let me give you a couple of examples. Harold Berman, giant scholar of revolution theory, defines revolution as, quote, rapid, discontinuous, violent change that bursts the bonds of the legal system. David Close defines it as a sweeping, sudden, violent episode. John Donne, revolution is a form of massive, violent, and rapid social change. Chalmers Johnson, revolution is change triggered by violence. Samuel Huntington, revolution is the violent domestic change in the domestic political institutions of a society. Charles Tilly, I have two more. Charles Tilly, revolution is the seizure of state power through violent means by the leaders of a mass movement. And of course, we can't talk about revolution without mentioning Hannah Arendt, who says that without violence, an episode is not a revolution, because only where violence is used to constitute an altogether different form of government can we speak of a revolution. I think what's perhaps most interesting to note is that revolution theory, as identified and as represented by some of the scholars whose work I just cited to, revolution theory doesn't regard these three themes, the violence, mass mobilization, speed, doesn't regard them as merely correlative of revolution. That's to say, they don't just observe a reasonable correlation between revolution on the one hand and violence, mass mobilization, and speed on the other. Nor does revolution theory regard these three propositions as simply illustrative of revolution. I think quite the contrary. The relationship between revolution and these three themes in conventional theories of revolution is really much more substantial. It's definitional. And so revolution theory regards these three themes as conditions precedent to revolution. And so in formulating a theory of revolution, conventional revolution scholars disqualify from the realm of revolution those episodes that are not violent, that are, for example, slow moving, unfold slowly and not the result of a bottom-up event. So they disqualify episodes that may be peaceful, even though they may be revolutionary in their achievements and their ends. Likewise, where transformative change is not wrought by mass mobilizations, conventional theorists of revolution, they make it hard to view those particular changes as revolutionary. And so this is the prevailing view. Just as a background, this is the prevailing view of revolution as it currently stands. And so you might ask yourself, why does it matter that revolution theorists focus on process instead of substance? And I think one of the reasons why it matters is that it allows revolution scholars to speak in the same breath of the American, French, and Russian revolutions, because these now form the central canon of revolution theory. They're entrenched in the canon, perhaps even more so collectively than individually, but we have to realize that there's more to these three paradigmatic revolutions than simply violence, mass mobilization, and speed. Yet the myopic focus of revolution theory obscures these very real differences that exist among these three paradigmatic revolutions. And so without a normative lens, I think, with which to assess revolution, we're left with this very unappetizing prospect of grouping the American, French, and Russian revolutions together under the same umbrella, not to mention the Iranian Revolution, the Haitian Revolution, what's going on right now around the world in the Middle East and North Africa. I think the larger concern that I have and that I will try to give you a way to think about remedying is in a second. My larger concern is that conventional revolution theory forces us to suspend moral judgment about the nature of our human interactions. And it moreover compels us to look upon the study of revolution as a descriptive inquiry. What is a revolution? All the while giving very little attention to, I think, what is a critically important normative question, which is to say, what purpose does revolution serve? So, this is a problem as I perceive it. You may or may not agree. If we think it's a problem, how might we begin to remedy it? I think we can begin by maybe discarding this procedural understanding of revolution and instead considering a democratic revolution with a very specific definition. That way we can maybe begin to bifurcate democratic revolutions from non-democratic ones. So let me take a crack at a democratic revolution definition. I'd like to suggest that it's something that occurs when challengers self-consciously adopt non-constitutional means to transform the state with the consent of their fellow citizens. I think this is a theory that begins to help us define revolution according to its means and its ends, not just its means. And you might have noticed that this idea of a democratic revolution rests on 5 pillars. There are 5 elements to this definition. The first is that a successful democratic revolution must transform the state. It must result in a structural change in the legal or political authority. Second, it has to achieve this transformation through non-constitutional means. Non-constitutional means. And by non-constitutionality, I mean to suggest that there has to be some element of extraordinariness or irregularity in the tactics deployed to transform the state. And these tactics have to venture beyond the methods considered lawful or constitutional at the time the revolutionary undertakes her democratic revolution. The third point is that the revolutionary must adopt these non-constitutional means self-consciously, knowingly, and in full appreciation of the consequences of that particular undertaking. And so in this way, a democratic revolution has to be an intentional effort on the part of the revolutionary to break from the present and propel herself and her state into a new tomorrow. Fourth point, the transformation must be contested, must be opposed by some segment of the citizenry. I think this is a very important component of a democratic revolution because it makes the revolutionary and her allies challengers to an existing regime, which they seek to displace with their own vision of what the regime should be, a new regime. And finally, a democratic revolution may be regarded as successful only if it is viewed as legitimate in the eyes of the citizenry. You might call this the principle of the constituting and the continuing legitimacy of the regime. So I think these are 5 elements, very broadly outlined, that help us begin to think about what it means to describe something as a democratic revolution. And my aim is not to redefine revolution entirely. It's really instead to devise a new syntax, to begin to think about a new syntax that allows us to remedy some of the difficulties that I've perceived in conventional theories of revolution. 2 more points I'd like to make before I cede the rest of my time. Why must the transformation of the state be a central pillar in a democratic revolution? Why must the transformation of the state be a central pillar? Well, I think it has to be a central pillar because we need to distinguish a revolution from other episodes, like a coup, for example. And the idea of transforming the state helps us do that. A coup doesn't transform the apparatus of the state, meaning that it doesn't result in a structural change in the legal or political authority. A coup brings about only personified change in legal or political authority. Structural and personified change, those 2 types of changes are qualitatively different. And the former signifies a revolution and marks an important discontinuity in the state and in the very basis of its authority. Personified change, however, only replaces the governors or officers of the state, usually only the highest ones. And that's what happens in a coup. It's also therefore likely to maintain continuity in the legal system, unlike a revolution, which results in structural changes in the legal or political authority of the state. Last point is, why must the transformation of the state, under my understanding of a democratic revolution, why must the transformation of the state occur non-constitutionally. Non-constitutionally. I think the answer is that not only do we need to distinguish a revolution from a coup, but we also need to distinguish a revolution from reform. And the concept of non-constitutionality, I think, helps us do that. Revolutionaries must use non-constitutional means, by which I mean unlawful means, illegal means, unconstitutional strategies to realize their transformative objectives. In order to launch their revolutionary transformation of their state, they have to deploy irregular tactics to do so. And those tactics cannot be consistent with the procedures authorized by the existing constitutional regime or otherwise deemed acceptable under the terms of the existing legal order at the time they are deployed. They have to instead use uncommon means by which to effect some desired change to the face and fate and form of their state. And those means have to be perceived as irregular. They have to be perceived by their citizens, fellow citizens, as irregular. That I think is an important point as well. And these irregular beginnings, this category of irregularity, helps us distinguish a revolution from another type of political transformation that does not entail as comprehensive a redefinition of the controlling legal and political authority, namely a reform. So I think this is where it does the work. Reform I see as an effort to achieve some lawful measure of change, which can of course sometimes be as far-reaching and as consequential as revolution, but that is done through the normal course of evolution in a particular state. A revolution is not that. A revolution is something that disrupts continuity, that establishes a wholly new regime. Reform instead maintains continuity of government and continuity in the legal order. Just as I close here, Rick, my purpose is, in this project, is not to rethink all of revolution. And it's more than to just redefine it. I want to redefine it in part, yes, but that's only insofar as I want to think of a category of democratic revolutions. And I'd like to introduce a normative dimension to the concept of revolution. And I think with this theory I've outlined, or the beginnings of this theory that I've outlined, I think we can begin the work of distinguishing between revolutionary episodes that celebrate the democratic spirit of humanity, for instance, if you agree, the American and French revolutions, from those that actually suppress it and depress the promise of citizenship. For example, we might point to the Iranian or the Russian revolutions, for example. So that's my immediate purpose. My larger purpose, though, is to help make revolution theory relevant again and useful in the face of the potentially seismic changes that we are now seeing unfolding in the world around us. Thank you for your attention.
Now, Professor Don Horowitz.
Well, I like the sequence of this because I'm post-revolutionary. I was in a Chinese restaurant a few months ago, I'm not making this up, and I got a fortune cookie. I opened it and it said, "Present your best ideas to an eager and welcoming audience." So if you do your part, I want to talk about institution building, including constitution making, in the context of radical regime change, such as the revolutions that occurred in Egypt and Tunisia. I'm going to make 4 points in sequence, and I'm going to go through them rather quickly. This is a survey course for the next 20 minutes. First, the first question is whether to use the old constitution or to abolish it. The second is, when you make a new constitution, as inevitably when you're coming out of authoritarianism you will want to do, what's the process supposed to be and how do you sequence it? Third has to do with the substance of constitutional choices. There are some non-standard arrangements, and I'll say what I mean about that down the road, that are likely to be required in societies that are severely divided between ethnic groups, and that's a lot of societies around the world, ethnic, racial, religious groups. Lawyers need to know something about these things, and they are catching up. Academic lawyers, I mean, but they're not catching up fast enough to meet the need. So first, then, the question of whether to use the old constitution. need to get my water. The old regime may have lost its legitimacy, but the people who come to power in the transition phase have, at most, only goodwill, not real legitimacy. So in some cases, if the old regime authoritarian constitution is serviceable to make changes, one could use it to produce a new constitutional order, as the Indonesians, for example, did when they gradually amended the 1945 constitution after the fall of Suharto, 1998 to 2002. They managed to use the authoritarian institutions for democratic purposes. And by doing so, they avoided a break with legality. If, on the other hand, the old constitution isn't even serviceable enough to get to free elections, you might want to strike those provisions that prevent free elections, and then enact a law legalizing parties, providing for free assembly and speech, and also enact a new electoral law. The point here is to do as little innovation at this early, less legitimate stage as is necessary. And furthermore, you don't want to lock your successors in to choices hastily made. Now, I'm going to continue with this theme in a different way when I deal with question 2, the process and the sequence. You note that I said free elections. Why would you want to have elections before a new constitution, before you knew what the panoply of institutions was going to be? It's not always the best way to have elections before the constitution, but I want to argue that it's frequently the best way. Habitually, you'll read in the press that there needs to be a new constitution before you can have elections. There are 2 strands in the new literature on constitution-making process. The first one says something like this. I'm going to caricature both of them if you don't mind. I just don't have the time to go into them in depth. The Constitution should be made by a thoroughly participatory process. The public must be educated about constitutional issues and choices, and the public must be thoroughly involved in making those choices. The public must, in the words of one writer, take ownership of the process. This view, it seems to me, isn't really wrong, but it is grossly overdone. It ignores what the economists call rational ignorance. That is, why should random members of the public invest heavily in learning about constitutional issues? Even those who make the new constitution will probably only do it once in a lifetime. It's a real question how much they should invest in it. Moreover, if a constitution is made by an inclusive representative process, that is, if it's preceded by free elections, direct public participation doesn't need to be quite so thoroughgoing. And in any case, if there's some deficiency in public engagement at that stage, one can also use the technique of the referendum afterwards. Referendum is a downstream constraint on what the representatives are going to do. You'll notice that I said the Constitution should be made by an inclusive representative process. And that does imply new elections before the Constitution is made. This is far from the universal sequence, but I think it's a good one, and it's the one chosen both by Egypt and Tunisia, likely with much better results in the latter than the former. The Indonesians did that too, and it gave them time to reach consensus in a badly divided society, and to proceed gradually. And as they went along, they corrected errors made at earlier stages. If you do one-shot constitution making, obviously you can't do that. Rush constitutions are generally a bad idea. Constitutions are typically made in crisis, and the more you can lower the tone, the better your deliberations are likely to be. And if elections come first, it takes the time pressure off, especially if the legislature itself is going to make the Constitution. And that brings me to the second strand in the literature on constitution process. It's a strand with one author, but many pieces. The author is Jan Elster. He says constitutions should be made by a detached process, by people who will not benefit from its provisions. This is to avoid biasing the results in favor of particular political institutions that favor some participants. Now, I have found that one should always listen to Jan Elster, except when one shouldn't. And this is one of those rare times. Politicians have to live with the new Constitution. and have to work with it and work under it. And that suggests that they should be involved in crafting it. The last thing you want is a constitution that politicians find it hard to live with and wish to overthrow. And you can get that if you keep them out. Third, a few words about something that, ironically enough, lawyers know much too little about: constitutional choices. When I say lawyers, I mean mainly people like us in the room, academic lawyers. Foreign advisors in constitutional process often exhibit home country bias. That is, they think the institutions of their home country are worthy of adoption elsewhere. They're unaware that there's a large menu of democratic institutions out there to choose from. You may remember that after the fall of the Berlin Wall, the ABA had its Sealy program, and it sent people off to Eastern Europe to help draft constitutions, people who were American constitutional lawyers for the most part. Many of them, I suppose there may be somebody in this room, so I'm going to offend somebody. Many of them carried a commerce clause in one pocket and an equal protection clause in another, and in the back pocket there was a due process clause, and they recommended that if you to the people who had graciously invited them, that if those people adopted those institutions, all might be well. Now, no doubt, as I say, this is a caricature, but I like to call those people provision merchants. Do you know the World Bank definition of an expert, by the way? An expert is a person who has flown over a country in the daytime. We've had a lot of experts like that. For ethnically divided countries, and there are a great many of them, often those foreign experts thought that the best thing you could do in a severely divided society was to institute majority rule with strong guarantees of minority rights, and they thought that might suffice. It won't suffice in such a society. For one thing, in such severely divided societies, it's participation in governmental power that's at issue, and that's crucial, that all groups be somehow included and not excluded. Ethnically based political parties plus majority rule implies that there may be no prospect of alternation in office if there's a majority represented by its ethnic party and a minority represented by its. Rather, there will be, as the minority sees it, perpetual exclusion from participation in government. For another thing, the enforcement of minority rights itself is problematic in post-conflict societies or newly democratizing societies, even with the best crafted provisions for a constitutional court. Because, and we need to recognize this, the rule of law and an independent judiciary to enforce minority rights often follow rather than precede the establishment of democracy. Don't be deceived by the British sequence, in which the rule of law was growing up gradually as the monarchy's powers were fading. Often the sequence is the opposite. You have a democratic transition and then a very hard slog to get to the rule of law. So if you have a constitution with robust minority rights, those rights may not be enforced. And as I said, even if they were enforced, they wouldn't be adequate to the task. So some special institutional arrangements may be necessary in such societies. And there are two main competing theories. I'm sorry to say they're mostly in the political science literature, and every so often we do have to borrow from other fields, or better still, move over into those fields and participate in the development of their canon. The first theory, consociational democracy, prescribes a regime of elaborate group guarantees of political participation and group vetoes. It assumes that if everyone is included in government, there will be a compromise of conflicting claims down the road. The second view, I am, by the way, a critic of this view. I have to confess that I am an exponent of the second view. The second view, the so-called centripetal view, which, as it suggests, attempts to move things toward the middle in a badly divided society, toward compromise, prescribes institutions that are designed to encourage moderation and compromise, especially through an electoral system that provides incentives for politicians and parties to take account of the interests of groups other than their own. So let me give you just one example of such an institution. It's not applicable everywhere. A lot of this will be context dependent. Most of it will be, but let me just give you one, because that's an abstract formulation. To become president of Nigeria, you have to have a plurality of the vote. That is the largest number of votes, even if short of 50%. And you must also meet the second territorial distribution requirement. You must have at least 25% of the vote in no fewer than 2/3 of the states. This was adopted in 1978. It has survived constitutional changes, and the purpose of it is pretty obvious. But I can tell you more specifically what the purpose of it is. It's to prevent either two of the three main groups, which together comprise about 63% of the population, from ganging up against everybody else and capturing the presidency on a plurality. The idea is that politicians from the larger groups who are likely to run for president will have to make deals across the country, and they will have to behave in accordance with those deals, or they won't be reelected. The nice thing about these incentives is that they are based on the uniform wish of politicians not merely to be elected, but to be reelected. My fourth and final observation it pertains to electoral systems. Americans are bad on this. They think that first past the post should come naturally to everybody. And I'm not a particular critic of first past the post. What I'm going to suggest is it all depends. If they learn anything about alternatives, it's that list system proportional representation is the alternative to go and look at. And this is a particularly crucial choice between these two and among these and others, because the electoral system, above all, structures the behavior of politicians. It's the best handle you have to manipulate the incentives of politicians as they think about their publics. All of these, I want to say, are highly contextual judgments. I forgot to say something. There's an array of electoral choices out there, and there are ways to rejigger list PR and plurality elections too, to produce an array of votes. And not just that, but majority runoffs as well, if you want to say there are three main alternatives. But there are many others: a single transferable vote, a single non-transferable vote, the alternative vote, and so on and so on and so on. We can go on and on with these choices, and typically foreign advisors don't know all of them. All of these, as I say, are highly contextual judgments. You need to structure the process so as to maximize the prospect of constitutional consensus and commitment by politicians to the new institutions. And you need to structure the new institutions to prevent the emergence of groups that feel locked out of politics, and the emergence of institutions that facilitate compromise. And you need to choose electoral systems that provide appropriate incentives for politicians to behave well. So, for example, list system PR, I hope everybody has an idea of how that works. Parties put up lists, usually at the constituency level, multi-member constituencies. The party that gets 10% of the vote gets its first, if there are, let's say, 100, a list of 100 gets its first 10 elected, and so on and so forth. There are many refinements that we don't have time to talk about here. But what I want to say is list system PR is not a system that provides any pre-electoral incentives for politicians to behave in a conciliatory way toward members of groups other than their own. Rather, list PR tells politicians to cultivate their own supporters because they don't risk not being in Parliament if they go that way. But if, on the other hand, they attempt to cultivate people who are not their supporters, they may lose their own supporters. With that, contrast the Nigerian system that I mentioned a minute ago, the Nigerian presidential electoral system. So suppose you have a society badly divided between the A's and the B's, and the A's are 60% of the electorate and the B's are 40%, and each has its own political party. Because in badly divided societies, ethnic parties will be the ruler. Proportional representation in that case might lock the 40% group into a permanent minority status, allowing the 60%, the A's, to rule in perpetuity. Obviously undesirable. Let's suppose, and this is, here's the contextual part. Suppose you start out with something different from 60-40. Suppose you have 5 groups, each with 20% of the population. Then list system PR might be perfectly appropriate as a choice, because it will tend to reinforce that multipolarity. which is preferable to a majority-minority bifurcation, in which the majority will simply dominate the minority. I could go on in very great length about this particular example, but I will not do so. One more example, and then I will conclude. Suppose, on the other hand, as in Tunisia and Egypt, that you wanted to help the liberal secularists who are in the middle. They're caught between Islamists on one side and friends of the old regime on the other side. And it's generally believed that in both countries, Islamists will have a large fraction of the electorate, perhaps as much as 25%. Not a majority, but a large fraction. And it's also believed that people who are friendly to the old regime, its former adherents, those who are sorry to have seen the revolution occur, will be able to organize, whether under a party label or not, and they will be able to, if they're local notables, they will be able to persuade local electorates to support them. Now, both of those countries had a history of majority runoffs in multi-member constituencies. I feel I'm using terms that are not familiar, so let me tell you that to be elected, you have to have 50% plus one, and if you don't get it in the first round, there'll be a second round. Majority runoffs, however, are likely to produce disproportionate results in favor of the largest parties. That is, they're likely to produce what we call a seat bonus. Candidates and parties will receive more seats than the proportion of their vote share would have ordinarily entitled them to. And if you're worried about a fragmented liberal secular center, which isn't organized into big parties, and you were asked to advise how to make sure that those people enter parliament, because if they continue to remain fragmented, they won't do very well in majority runoff constituencies at all. Their support may be nationwide, and it may be at a relatively low level. Perhaps it's also 25%, but it may not be 25% in many constituencies where local notables will have the edge. If you wanted to do that, you might very well opt for the most proportional system you can get, because at least then there will not be a seat bonus. But even with a low threshold to get into parliament, some of these parties are going to be excluded. Therefore, for the first election, it might be a good idea to have no threshold, to have any party that gets 1 divided by the total number of seats elected to parliament. The authorities understood this because in both cases, they have loaded the dice, much more in Tunisia than in Egypt, but in both cases, they have loaded the dice into very highly proportional systems. The Egyptians have a mixed system they're proposing, and they have kept some of the constituency seats. The liberal secularists in the center understand that this is not in their interest, and there's some move to get a further amendment from the transitional government in Egypt. I want to tell you one story before I finish. About more than 15 years ago, I had lunch with a federal judge I know, and she told me that she had recently come back from Albania. I said, oh, what were you doing? She said, I was helping them draft their new constitution. I said, was Albania a country that you had prior experience with, or did your family come from Albania? And she blushed, and she said, no, to tell you the truth, I had to look it up on a map. I'm afraid I was a little unkind, because I said to her then, at the Constitutional Convention, were the differences between the Gegs and the Tosks, which run throughout Albanian society, wherever Albanians are, very visible? Do I need to tell you what her answer was? Who and whom? This is no longer, the days of amateurism in these enterprises are over. And it's time that lawyers and law professors develop some expertise in this field, because if you don't, you're left with other people giving advice who don't have that expertise. There's a lot of custom tailoring that's necessary here, and whatever you do, if you get into this field, beware of simply buying institutions off the rack. Thank you very much.